Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. So Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things you've Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you are, you're my everything. See, I call you Jireh. Lord, my provider. I call you Eunice. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. Lord, my provider. I call you Eunice. You are my battle. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything. Buya matinyana. Buya matinyana. Buya matinyana. Oh, buya matinyana. Yeah, so buya. Buya matinyana. Buya matinyana. Yeah. Buya matinyana. Buya matinyana. Say, I call you Jireh, say. I call you Jireh. Lord, my provider. I call you Eunice. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are my everything. Yeah. Are you ready, everybody? All right, listen. Will you make one cover? 1, 2, 3. And we are live. Hello, good afternoon, lovely people. This is the opportunity for you to meet us and the wonderful law organization BWF Solicitors as we bring you the community and the law program. My name is Orueku Frimpon and I have the honor and duty to host this program. And today I'm asking the question. And what I want you to do is to get your calculators out and ready. We are going to count some days. And what are we counting for and why are we counting? The question is, how can I demonstrate to the Home Office that I have not left the UK since my arrival 20 years ago? So if we're talking 20 years ago, we're talking about what, 2003. Between 2003 and 2023, how many times have you left continuously in the UK and how do you prove that to the Home Office? That question will be answered. So I want you to join us as we go live on BWTV, BW Radio, BWF Solicitors Facebook and all the social media platforms. Once again, let's jump into it together, the community and the law. Hello. Yes, I'm quite busy doing what I was going to ask you to do first of all. But let me say thank you very much and welcome to the show. Welcome to the community and the law. I'm doing what we're supposed to do. I've picked up the uh, link and I'm sharing on my platform. I put that on my network. And of course, everybody that is so linked to me is going to get the link. So we do it together. Good afternoon, as the third Saturday of the month, February 2023. Now, between 2003 and 2023, how can you prove to the Home Office that you have not left the UK? How do you do the calculation? What is it that the Home Office requires that you need to do that calculation? Lawyer Patrick Rye will be telling us that and will be showing us how to do the calculation, how to prove to the Home Office that we have not left. And if it is that we have left, what are the consequences? Are they dire or whatever it is that we have to show them? We will be taught today on the program. The program is brought to you by BWF Solicitors, our trusted legal partners when it comes to the law and especially in the community. BWF Solicitors are at 214 to 218 Tottenham High Road, Seven Sisters, North London. They operate between Monday and Friday, 9:30 a.m. and 6 p.m. And when it comes to immigration issues, when it comes to settling in the UK, about your family and the law about your wife, your husband, your children, and also all the legal matters, employment, education, everything. If you want to buy a property in Ghana, talk to BWF Solicitors. BWF Solicitors, 0208 493 7340 or 077 127 61884. Now, they are so proud to be part of the community and they are bringing you the community and the law. So let's give them credit. I'll be right back.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Hello, and thank you for your time. Thank you for your patience, BWF Solicitors. We so appreciate you, and we'll definitely be coming over to you for all our legal needs. Somebody has just texted me, I am in Ghana, I need assistance to get to the UK. Yes, if it is that you want to consult BWF Solicitors, you can call them on 0208-493-7340. Okay, now let's see who is on there on the platform. When you come in, announce your presence, and let's see you. Rebecca Marcon, thank you very much for coming around. Iqbal Masi, good afternoon to you. Ejiwa Nana Ajimain Ademunukum, and all the wonderful people that have joined us. Thank you so very much for joining us. When you come in, you do two things. One, announce your presence and definitely ask people to share. Then the next one you need to do is definitely to pick up the link and share. Remember, you would love to like the page and click on the notification button. That sweet little button there. Click on it and let's stay in touch so that any material, any content we put on there, you would have the notification and join us immediately. Gloria, yeah, Abaya, it is saying, thank you very much for joining us. We have Ajay Kwabena Sapon, who's also joined us. Ajay Kwabena, thank you very much. God bless you. And uh, good evening, everyone. Ajiwan and Ajimai has sent that to the platform. So very kind of you. Now, let's move on to what BWF Solicitors does so very well. At the start of the week, and I keep saying that from 12 noon up to the close of the day, you'd realize that BWF solicitors would have thrown something into the atmosphere on the scene. And what they tell us is what we are looking at to enhance our knowledge in legal matters. The nugget is what we're bringing you. And I am moving to read that for you. So when we get to introduce our guest and our resource person, he will expatiate on that. Surrogacy arrangements mean a woman carries and bears a child on behalf of someone else. The woman who carries and bears the child is a surrogate mother. However, she can do this without being genetically related to the child. The sperm and egg necessary to create the embryo can come from donors, and the embryo can be implanted in her. In such circumstances, any resulting child may have no genetic connection with a surrogate mother or a husband if she has one. Under UK law, when a child is born to a surrogate mother, the parental responsibility for that child rests with the surrogate mother. In this case, the father of the child is the husband of the surrogate mother, or if she is not married, the biological father. It's a bit long winding, but I believe that when we have the explanation, lawyer will just open it up, spread it out, and unpick them one after the other. Now, this that I read was quoted from Section 59(9)(c) of the British Nationality Act, read in conjunction with the British Nationality Proof of Paternity Regulations 2006. Surrogacy arrangements, what are they? Who is the mother? Who is the father? Who is the husband? Who is the wife? What happens? Under UK law, what is the nationality of the child and the rest of it? We will be definitely looking at that. But before then, let me once again pay tribute to BWF Solicitors, and I'll be right back.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Okay, well, we ride back and we're moving and soldiering on for God, country, our survival and everything. Brought to you by BWF Solicitors, and we on the program, the community and the law. Now, I read the nuggets as we have found there. We will be coming back to that, but I had a few other things I would want to bring to your attention before we move on. The next one is about the English language test that and the preparation that you do. Um, if you would want to write your English language, KT Education Consultancy will help you. But in the meantime, yes, the KT Education Consultancy, they help you write your IELTS, B1 and B2 for skilled worker visa routes, for health and care worker routes and student visa applications. If you were on the show yesterday, the senior partner, Uncle Ben, went through the process and also told you how very well you can get your English language, what you need to have on your visa and your application and the rest of it. The video bit of that is on social media platform, and you can keep that with yourselves and within your network. Now, if you want to apply for a visitor's visa, and any visa at all, I would want you to join BWF Solicitors Group and the army of supporters, army of benefiting customers. How do you do that? Just give them a call, 0208 493 7340. They have an office in Ghana. So those in Ghana, you can call 050 462 2794. 050 462 2794. BWF Solicitors, they are our trusted legal partners when it comes to the law. Now, I would want to really read the nugget again so we can go straight into that discussion. Now, it's talking about surrogacy arrangements, and we want to see what the law says, what the British Nationality Act says, and what the regulations are. Now, this is what I've quoted, and definitely when we're done, we'll come to look at what it is. As I said, a lawyer will unpick them and let us know the intricacies of the whole thing, the nationality of the child, who is the husband, who is the father, who is the mother, and the rest of it. Now, let's get to read this. Surrogacy arrangements mean a woman carries and bears a child on behalf of someone else. The woman who carries and bears the child is the surrogate mother. However, she can do this without being genetically related to the child. The sperm and egg necessary to create the embryo can come from donors, and the embryo can be implanted into her. In such circumstances, any resulting child may have no genetic connection with the surrogate mother or her husband if she has one. Under UK law, when a child is born to a surrogate mother, the parental responsibility for that child rests with the surrogate mother. In this case, the father of the child is the husband of the surrogate mother, or if she's not married, the biological father. Now, this is quoted from Section 59, 9C of the British Nationality Act. And I read this in conjunction with the British Nationality, that is Proof of Paternity Regulations 2006. So, what does it mean? Who is the father? I am the mother. I have gotten the sperm and the egg together, implanted in me, the embryo in me. I have a husband. Is my husband, me, the surrogate mother, is my husband the father of a child? Or who is? Who is the actual mother of a child legally? We want to look at that because in this situation, there are two women, there may be two men, and we have to define the role of each of the individuals in there. And with that, let's go to the scene. I will welcome my friend, my brother, and my colleague. If I say colleague, people don't understand because I am not a lawyer. So how can a lawyer be my colleague anyway? Lawyer Patrick, good afternoon.
Good afternoon.
Thank you very much for coming and having time for us once again.
It's always a pleasure.
Good, good. And I hope the family, everybody's well.
We're all doing great.
And the week has been good?
Well, week is obviously flown by, so here we are, ready to start another one.
Well, interestingly, January was a bit slow, but February is running too quick.
It is actually racing through, and well, for some maybe it's good, for others maybe not. So if you're expecting to be paid at the end of the month, then
it's good.
It's
but
good.
If you're expecting to pay, it's running too fast.
That's right. Yes. So it depends on which side of the fence you're sitting, really, to be honest. Yes.
Good. I have this very interesting. It's not a dilemma, but it's a technical situation, especially when it comes to the law. When we talk about surrogacy, the definition: the embryo is implanted into a woman, gives birth on behalf of another person. Who is the father? Who is the mother? Who technically the child, of what nationality would the child be, and the rest of it. You're here, and not to put you on the spot, I know definitely. How do I unpick these?
Well, again, thanks very much for the opportunity to come and sit on the table again with you. Now, I think this is a topic that we've dealt with several on this platform and the other ones. On top of my head, I think our senior partner is dealt with it maybe 2 or 3 times. And, we don't take delight in coming back with the same subject. That is not the idea. The idea is to impact knowledge. And where we feel there's a gap, the intention is to plug up that gap. And that is why we come back sometimes, maybe, with the same topic to drum home what it is that we need people to understand. And so this is why this is important, that we get to understand what this is. Because not many people understand the area. It is not used, and the focus is always being on FLRFP, I'm going to marry somebody and then I'll be able to stay or enter the UK. What we're trying to do is to make people understand beyond FLRFP, FLRM, there are other routes that you can explore to come to the UK. And these are some of the routes, or if you like, some of the areas where we think our community is not focused or explored as yet. Now, we've also discussed in the past on this platform, I suppose, last couple of programs, the definition of who a father is in terms of our nationality law. And so we saw in that discussion that a father of the child is, as defined in the 1981 nationality law, section 59A, is the person or the man to whom that the mother who is giving birth to that child was married to at the time.
Okay. Yeah.
So we saw from that discussion that irrespective of the fact that this person is not the biological father, it may be the case that because of our the way our nationality law is being couched, this person would be, perceived to be the father of the child. And to that effect, if you were pregnant today and you were married to somebody else who is not the biological father, then you would expect your child to assume the nationality of that person. And you'd be disadvantaged if this person, for instance, is not a UK national, but then the biological father is a UK national. And your expectation was that this child would be born
automatically a British citizen. You'll be disappointed. We saw that that particular legislation cuts both ways. It's a two-edged sword. And so there can be a situation where the mother is giving birth, but then was married to somebody who is a UK national, but the biological father is not a UK national. And to that vein, that child, again, will be born automatically a British citizen. Now, bring that to where what we're discussing now, our nugget. Now, surrogacy, as our senior partner has discussed a few times, is a couple commissioning somebody, maybe a friend, sister, or anybody at all, to have a baby for them. I think that would be the simplest form to explain this. To have a baby for them. So he explained that there are various options. There's an option where extracting the man's sperm and fusing it with the wife's eggs, and then implanting that into another woman's womb to carry the baby until such time when the baby is born. And there's the option where perhaps the wife of this man cannot produce eggs, and so the eggs, the sperm of the man is fused with another person to create that, or two separate individuals are put together to create that, to put into the wife's womb to make the baby. Now, in all of these, we're looking at who becomes the father, and what nationality would the child be having. Yeah. That's right. So, in a situation where the father and the man and the wife commissioned somebody else to do it for them on their behalf, what we're seeing is that we have the man's sperms and the woman's eggs put together, fertilized, and then we have a baby. In that instance, from what we've seen, if any one of these two are British nationals, then of course the position of the law is that this child will become a British citizen. Right. And that is even if they were born outside of the UK. Okay. So the nationality law allows for them to assume the nationality of the parent. Back before 2006, when the law changed, it wasn't like that. So it was the woman who would have been able to pass on their nationality to the child if, say, for instance, she was not married to the man at the time. But then since July, when we've obviously done some changes to the nationality law, now it's possible for the man to pass on their nationality to the child, even if they're not married to the mother of the child. And so that is how it is with what we're discussing with this nugget. So if you commission someone to have a baby for you and your wife, and this person's got no genetics whatsoever with this child, then of course, indeed, if your husband is a British citizen, you're expecting this child to assume the nationality of your husband.
There's one little bit of technicality around it. Now, I have commissioned somebody to carry my baby for me during pregnancy. The woman has a husband, but I've taken up the contract. Would the husband have any relationship with the child that the lady is carrying on behalf of another person?
So we've seen from the introduction that where the mother of the child is married to somebody else, then when the child is born, it will be that person who the mother is married to that would be perceived to be the father of the child. And so from the question that you've just asked, if this turns out to be the case, and the surrogate mother that you've commissioned is married to somebody else at the time that the child is born, then unfortunately,
this person would be, per the nationality law, be classed as the father of the child and would assume
So
their nationality.
strategically, if you would want to have something like that done for you, then you go for somebody who's not married and possibly somebody who's not related to you.
Well, it's advisable to do that. Do your research because of the intention. So first of all, the intention perhaps is not only just to have a baby, but then to have a baby who would, assume your nationality. And so if you're a British citizen, what you're looking to do is to have your child who would eventually become a British citizen for easy passage to the UK. And so therefore, if you've not done your research and you've commissioned somebody who is married to somebody else and the child is born, then unfortunately, the person who this surrogate mother is married to would be the person who would be classed as the father of the child and would take their nationality. So therefore, it is advisable to do your research and make sure the person that you're commissioning is not married and they are contracting, and therefore you know that they are not married. And if the child is born, because it's your sperm that has been used and it's been fertilized, yes, it's your child, and you can pass on your nationality to this child.
Well, if you just joined us, we on the community and law, and I believe that you have picked up the link and you have shared for people to also benefit from. Surrogacy is what our nugget has brought us, and we have had the lawyer discuss that and explain that fully for us. Now we're going to pick up our main question, and that's one thing. You realize in his introduction, he said that we don't necessarily want to be repeating topics, but if there is a concern within the community, then it has to be picked up to be addressed. Now, we're looking at the Home Office says that you would want to apply for long stay, having stayed in the country for 20 years. Now, how do you prove that you have not gone out or you have lived in the country for the 20 years continuously? Have you had that continuous stay in the country broken one way or the other? How do you prove that? How do you calculate that? Listen, there's an answer. Don't get confused. But what I would want you to do, you are very lettered. You can pick up your pen and paper and write those things down, or pick up your calculator. We'll be doing some calculations here and there. We'll be telling you what 90 days is, what 180 days is, what 450 days are, and all the details. All these, we'll be back with that after the short break.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community,
is a member of the Family Law Panel
and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
BWF Solicitors, your trusted legal partners when it comes to law. Now, Lawyer Patrick is here, and today we're going to look at that question that I've posed over and over again. How can I demonstrate to the Home Office that I have not left the UK since my arrival 20 years ago? In my introduction, I mentioned to you that let's look at 20 years ago, which is what, 2003. And have you left? If you have, what are the consequences? How do you calculate if you had to leave and you came back and you be penalized? Is there any punishment at all? Let me go to Patrick. If I have been here for 20 years, I assume that I'm applying for a long stay. How do I prove to the Home Office that I have?
Right. So, what we're discussing today is the private life route.
Okay.
I think people back then knew it as paragraph 276A. There's been changes since last July, and now we know it as paragraph private life. So before 2012, if you lived here for continuous period of 14 years, you were able to apply and be considered for indefinite leave to remain. You were able to combine lawful residence or unlawful residence to make up the residence to qualify for the so since 2012, we know there have been changes, and now to qualify to live in the UK without any leave or combination of that, you would be looking at 20 years. So 20 years.
You said combination of that. What do we combine?
So what that means is that you could combine living here lawfully and unlawfully
Okay.
to make up the 20
The
years.
20 years. Okay.
Because there are situations where somebody is being granted maybe leave to remain at some point in their lives here, and perhaps something happened and they couldn't renew, and since then they've lived illegally. So you could combine all of those leaves and your unlawful residence here to make up 20 years to apply for to remain.
Okay.
The unfortunate thing is that now you don't get indefinite leave to remain. What you get is a 2.5 years limited leave to remain. Then you renew that 4 times to get your indefinite leave to remain. So you're looking at, say, living in the UK for 30 years to be able to obtain indefinite leave to remain. Now, with the 20 years, even if you've lived here illegally for that period of time, you are still able to apply if you meet all of the other requirements. What you're looking to demonstrate is that you've lived here continuously for that 20 years. And that is where the difficulty is. The reason is that once you're here illegally, you are not allowed to work. And so there are times when people are not even using their own name, but they may be doing other things underground. There are also times that, people, because of the fact that they are scared of the consequences, are not even registered with a GP. They don't have a bank account. They are not, even since 2014, 2016, are not even allowed to open a bank account, rent a property, and all of those things. So therefore, you can appreciate that it will be very difficult to prove this if you are that person who is lived here for all of these years, and for the fear that somebody might find you out and then grass you up. You've not opened a bank account, and you haven't got, if you like, anything at all in your name. But really, you've lived here for 20 years. Would you be able to go and come back if you don't have leave to remain?
Right.
And so, yes, in fact, you've lived here for 20 years, but then you're not going to go telling the Home Office that, in fact, I've lived here for 20 years. The onus lies on you to demonstrate that. And you don't demonstrate that by just verbally telling someone
them
that.
left here.
Yes, you have to demonstrate that by providing the evidence that supports your claim.
And it becomes very tricky. You are living here, you are not allowed to work. So, for the fear of that, you have not registered with GP, you probably do not have a bank account, you don't pay slips and all that. But then the evidence is documentation. How do you go about that?
Well, so that's a very good question. We've seen from a case that we have dealt with that the Home Office did their own search and found out that this person had used somebody else's name to work and had opened a GP in somebody else's name, and so wanted that evidence so that they can close up the gap, which was obviously open. So they requested for that evidence. Bear in mind, this person did not volunteer that evidence. However, the Home Office did their own checks and found out that indeed we can see from our database that you've used this name to do this and that before. You've registered with a GP with this name on this date and that. So then, if you can provide the evidence, then we'll be able to reconsider your application. So,
is that not a trap?
well, to say that's a trap is, a very good question. But there's a case called Mahmood, which has taught us a lesson that if you use somebody else's name to work and you have the evidence to provide to demonstrate that it forms part of the continuity of your residence, then that should be accepted. So, yes, good question whether it's a trap or not, but Mahmood tells us it's not a trap because you can use that. And so, when this person provided the information, yes, indeed, the end story is that they were successful with the application. So we know it's done. Now, my problem is, just like you say, the Home Office is the Secretary of State who has created this hostile environment which has stopped people from staying in the country legally. So therefore, if you're here illegally, you're not allowed to do so many things. If you're not allowed to do so many things, then it's going to be very difficult for you to demonstrate that continuity of residence. And so where do you get the evidence from? This is the person who is put impediments in your way, therefore, so that you cannot obtain the documents that you'll be able to use to support your claim. And it's the same person that is asking you to provide this evidence. Now, the 20 years that we're talking about, it's not saying, well, I've lived here for 6 months and you provide. They want to see throughout that 20 years evidence that supports the claim that you've been here continuously for 20 years at the date of your application. And this is very difficult. Now, those who have, been registered with GP since they arrived, very lucky. You can go and ask for your GP to provide you the data, and you'll be able to plug some of the gaps with that data. So that's fine. If you open a bank account since you arrived, especially those who came before the changes in 2014, 2016, when people were obviously not scrutinized and were allowed to open bank accounts and that, you'll be able to use to to support your claim as well. So if you imagine somebody who came in after that, or who perhaps for fear of being arrested, did not even bother, even though they came in for that time, they don't bother to open a bank account or register with a GP and the rest of them. You can appreciate that they wouldn't have the document to support that claim. It makes it very difficult. The other thing is that there are some people who come and, for whatever reason, they feel that if I sent off my passport back, then I'll be here and nobody could notice.
I could get it stamped somewhere for me to evidence that I'm around.
That's right. And, so they don't have it. Or they've lost it, and so they can't find the original passport that they traveled on. Again, that's a problem as well, because the stamp or the vignette that you're given in your passport when you apply for your visitor visa or any other visa to come into the country is the number one key evidence that shows that, yes, you came into the country
at that time,
2001, 2002, 2000. So if that is missing, again, there's a bit of a problem. There's always a way to get that back, not the passport, but you can always request for your data from the Home Office, and you may get a comprehensive report, which may include that in there. And so you'll be able to demonstrate with that. The other issue is, for me, that the fact that they put all of these impediments in your way, the Home Office has a way of checking who is coming into the country and going out of the country. Back in 94, this was done. In 95, they decided to abolish it. And then 98, it was completely gone. Since 2015, they reintroduced it. And so now we have what we call the exit checks. So if you're going out of the UK, you'll be checked. If you're coming back in, you'll be checked. That's data collection. We also know that they collect information from the airlines. So when you are
the landing cards that we call.
Absolutely. So when you're going to go to Ghana in the near future, you would appreciate that if you're traveling on BA will ask for your advanced passenger information. It is not for fun that they ask for those details, because the Home Office will be able to check to see that you left the UK and came back. Okay. So therefore, if this is the case, why then do they require you to provide all of this,
because they have it
plethora of evidence to demonstrate that you haven't actually left the country? Because they have that information with them already. They are able to tell if you left or you didn't. Now, if you didn't have leave in the UK, who at all in their right senses would leave the UK and then come back? How? I don't know. But, it's somehow very difficult to understand that somebody will put themselves in that position, that they know they have no means of coming back, but then still will leave. Because the thing is, once you leave, if you leave for a certain number of up to 6 months, the continuity of your residence will not be broken. So therefore, say for instance, you were here illegally and you left and you came back, that wouldn't break the continuity of your residence. So you can carry on. So that's fine.
Okay.
But if you've left for 550 days combined together, then that will break the continuity of your residence. If you're in prison here, again, it wouldn't break that, but it would not be counted towards the residence. So yes, you can aggregate before and after your prison sentence to make up the 20 years, but not whilst you are in prison. So it's difficult. It's very technical, and yes, it's being granted because we've seen most of our clients going through successfully. But that is not to say that you may come across some caseworker who is very, very pedantic and want to tick all of the boxes to make sure that you've provided all of the things that they are requiring.
Now, I'm looking at the calculation situation. I came in 2003. They may ask me to show when I landed in the country, which they may have. But before I could say Jack and get a GP or even have a bank account, albeit in another person's name, I had spent 2 years. So, for instance, I came in 2003. 2005, I can have evidence to show that I have been here with a GP letter or something else. Those 2 years that I lost, have I lost it forever? Or I could ask them to investigate or say, I came in here, but until XYZ time, I couldn't open a GP or I couldn't have any documentary evidence to show that I'm in the country. Doesn't mean that I've lost those 2 years?
Well, not straightforward like that you've lost it, because the requirement is that you be able to demonstrate that you've been here continuously for 20 years at the date of application. Now, it's not always the case that you can provide all of the evidence for the 20 years that you've been here. A typical example is a question that you've just asked. And so there are times when we've requested for clients to provide statements from family and friends to evidence the fact that they've been here for that period of time. Again, those of you who like taking photos, you probably have gone to Trafalgar Square or Buckingham Palace and then taking photos. You know, back in the day, when you take photos, you have a date and time on there. And so that is, again, another very good evidence to provide to show that, yes, you've been here. So, yes, the 2 years could still be plucked up with other documents or evidence that you could get from other places. Again, if somebody is writing the letter for you, it is not very strong as though you're providing that document from a recognized institution. Yes, whatever the person is writing, technically, somebody may sit back and say, well, how can we prove the authenticity of
the letter or any
the testimonial that they're giving? So if, say, for instance, you're my friend, you're my brother, and you ask me to do something for you, the likelihood is that I will not write anything negative about you.
Right.
And so, therefore, the statement from family and friends, though may be considered, but it's lightweight, if you like.
Okay. Then the other thing is a testimonial, as you put it. I would have worked with an organization. When I got in there during the interview, I may have mentioned that I have been looking for a job for so number of years, or even to the point where I entered a job center and they told me I don't have any stay, so they're not going to allow me. Obviously, they would have taken my details. Would that be evidence good enough to show them that before I had any documentary evidence, I was walking around trying to find something to do?
Of course, that would be a very good evidence. I mean, as you can appreciate, in this country, we have data protection laws, and requesting for your information is allowed. So, for instance, if you've in the past approached the job center to find work and you didn't get it, yes, you may be able to write to them to request for the data that they hold about you, and you could use that in support of your application. Yes.
Okay. Any other thing that, okay, for instance, I have been able to demonstrate at the beginning, in between, around about the 10th, 11th, or the 12th year, I was unemployed. The person whose document probably was using, I fell out with, the person decided to take that away, warned me not to use his details anymore. That gap, would there be any way of filling up that?
Well, so yes, as we've mentioned before, you could use your GP registration if you've got one. You could use bank statements if you opened one at a time. If you've got friends and family members who can provide statements to support the claim that you've been here for that period of time, again, you can use that. It may not be accepted as strong evidence to support your case. However, that's the best evidence you have. So why not? You can still provide that to support your case.
Okay.
If you don't have the documentary evidence, it doesn't necessarily mean that you haven't been here for that 20 years that you claim you have been here.
Lawyer, you've made the point that you'd have to have evidence, proper evidence, acceptable evidence,
Yeah.
which might be documented.
Yeah.
If I do not have it, what do I do? Do I have to go beyond 20 years and live that gap?
No, you don't have to. You don't have to. The fact that you don't have the evidence does not mean you cannot apply. So the worst case scenario is that once you've applied, maybe for the lack of the evidence to support your case, your application may be refused. But that would not be the end of the story, because you would have the opportunity to appeal against that decision to the first tier tribunal. And that decision making becomes that of the judge, who is sat in the chair or in the high seat on the day of the hearing. So they would take a holistic view of what you've provided and your circumstance to see whether or not the Home Secretary is in the right to say, even though you don't have the evidence to support all of the 20 years that you've been here, they're still right to refuse your application. What about the argument that if you didn't have leave to remain, there was no way you could have left the UK and come back? And what about the argument that the advanced passenger information that we've mentioned is readily available to the Home Secretary? And the exit checks as well, the data is there. Why don't they provide that to support the claim that, yes, you have not lived here for 20 years? Even though the onus lies on you to provide the evidence to start with, but for the impediments that they put in your way, you are not able to do that. The hostility that they've created has meant that you have not been able to, obtain the official documents that they require from you to prove your residency here for that period of time. So therefore, if you've done your best under the circumstances to provide what you can, then I suppose the onus will shift now to the Secretary of State to basically topple you over with what they have to prove that indeed you haven't been here for 20 years.
So if I realize I have gaps in my evidence and I have lived the 20 years, the anticipation is that when I put in the application, it would be refused. So then I have the reasonable expectation to say that, one, I'm going to put in the application, it will be refused. My next step is to go and appeal to the tribunal for that to be considered. So then I start with that expectation and end in court. Would that be something I would legitimately have to do?
Well, I mean, if anybody who is submitting an application, unless otherwise you've spoken to an expert and they've analyzed your case and advised you that, well, this is what is likely to happen and this is the remedy you would have. Apart from that, anybody else who is making an application has got one thing on their mind. That application is going to be successful. And for them, it must be successful. It doesn't matter what the circumstances. So that's what, clients are expecting to hear, that application is successful, unless otherwise advised, of whatever is going to happen. So therefore, if you make the application, it is not to have the expectation that this will be refused and I'll go to court. You're making the application with the best of evidence that you have. You've done all of the things that you have to do. You've provided all of the documents you have to provide, and you expect that this application will go through. It is very important if you have the passport on which you traveled on, because that's the key, number one key evidence to support your claim that you've been here and not gone back, because they can check from the passport pages to see whether or not it's been stamped that you've exited and come back into the country. So if that is there, then that's fine. But if it's not the end of the story, because you've lost it. But then we have evidence that you traveled into you may even have traveled on a different name, but it's still you. So you came in and the records are there. You can go and then, extract that from the Home Office to support your case. So you have the expectation that you're going to be successful. But in the case where you are not successful, then you have a remedy. And that remedy is to go to court and then speak to an independent adjudicator of the case who would, look at things holistically and say, yes, on the basis of maybe probabilities, it is quite clear that this person is lived in the UK and it's not left the UK because if indeed they left, there would have been no way of them returning back without leave. And so, yes, we can, based on that, say that they haven't left. Yes.
If you just joined us, you're live on BW TV, we're live on BW Radio. We're giving Lawyer the chance to take just a quick short break, and we will be coming back to take your questions. The number we're going to use the ones we normally use, and that's on your screen now, 0208-123-1016 and 0739920848. You have a text, WhatsApp, or an audio note, you can send that to our text and WhatsApp number 07950422-780. So your questions, your concerns, and your issues are here. We're ready for that. And you can put the comments and the questions on the chat as well, whether you're live with us on Facebook, whether you're live with us on YouTube, we are able to pick up your questions. So I think the first one I would want to pick up will be from Raymond B. Nyame. It says, please, I am an IELTS facilitator in Ghana. Can you help my participants to get home care jobs here in the UK? I don't suppose BWF Solicitors
Well, of course,
home care jobs available.
unfortunately, no, we're not an employment agency, so we're not able to find your participants work in the UK. But we can direct you where to go to find the work. So if you go on the government website, if you're looking for care homes with sponsorship licenses, there'll be thousands of them. And you just go through and see which one you feel you can apply to. And once you're, given the job, you'll be provided with what we call course. That's a certificate of sponsorship. And then once you get that, then come back to us, and then we make the application and make sure it's successful. So that's what we can provide, but not looking for job for individuals now.
Okay. Another one, I think Tilly says is watching us from Kent. Tilly, thank you very much. Another one here is from, I think I saw one on there. Can we pick that one? Yes. My sister is applying for independent visa, but was refused 15 or 16 years ago. I don't remember the date, but she was refused, and the reason as well. What should she do? Secondly, she was refused as first time. The first name, Augustina, surname, well, you didn't have to provide that, but at least she was refused in a different name. But now she's applying, and the first name is Augustina, and the surname is Dia. This is because the passport office misarranged her name, and in order to sort it out and use it or to fill her forms, would there be a problem for her? If yes, what advice can you give to sort it out?
Well, I mean, if you use a name in the past, if you're asked on the application, you should be able to mention that. They'd be able to check from their data anyway that you've used this name before. And so you come out clean to let them know. If it was a mistake and your name is supposed to be what we've just read, then that's what you're saying. If not, then you can always get a deed of name change to rectify that and say, yes, I was known by this name, but I am known by this name. And so the old name that you knew before and this one that I have now, they're all one but the same person. They're not two different people. And that would basically suffice, yeah.
Okay. I have Newman that says that wants to book for an appointment with BWF Solicitors and meet the lawyer. Your short number is 0208-493-7340. When you call the number, you'll be able to book an appointment and see the lawyer
as your desire is. The number again, you can call in on 02 or 81231016 or 0739920848, 0739920848. Lawyer, this one is asking that if you used somebody's name as an applicant, or you've been working with that person's name, and you said to the Home Office that previously I operated or lived in this country under this name. Now this is my real name. Why wouldn't they punish you? Because it's a lie.
Well, they wouldn't punish you because, yes, if you use a name in the past and you've changed your name, you're allowed to do that. So maybe last year you were known as Samuel Ejipon. Now, this year you decided to change your name, and so now you're called, you know, maybe Fred Amoa. That's within your own right to change your name, so long as you have the evidence to demonstrate that. Sometimes it is not that you've changed it legally, but this was an alias that you used in the past, but this is your name. Yes, you can say that. But why should they punish you for changing your name? I mean, for me, it doesn't make any sense if they have to punish you, because it's within your own right if you want to change your name, and you can change it as many times as you want. If you change it legally, then yes, just provide the evidence that you change it legally, i.e., you've got a deed poll to support that. So there's not set number of times that you're able to change your name. Yes, you can do that. Now, the only caveat is that if, say, for instance, you're relying on somebody's name that you've used to work for the number of years to plug up some of the gaps, then you'll be required to be on the side of caution. Because bear in mind, if you're working illegally in a company, that company could be fined and be given a penalty as well. And so if you're not a person and you're going to go say, well, I'm the person, then you're opening up kind of worms, if you like. Yeah. So that's the bit that you probably want to be careful with. So if you're using your own name and you're working in that name, first of all, you are working illegally because you're not allowed to work. And so, apart from you committing an offense, the person who is employed you as well is also committing an offense. And so, therefore, there could be an issue with yourself and the employer. You may not want to get that employer in that difficult situation, because it may cost them about £20,000, you know, if they're found out. So yes, you can use the information. If you're currently working, then, you know, please be careful with that. But if not, and you've used it in the past, and you have the evidence, you have pay slips, you have P60s, and all of those documents from the high places to show that, yes, indeed, it is you've got these documents. And you can use that. I've done one for someone before, and we included everything, literally everything, and it was successful. So it's doable.
It's better not to lie than
Well,
to
yes, so don't lie. That we don't like. Be truthful, be upfront, and you're likely to be successful.
okay.
And if you're going to go and see a lawyer, please don't sugarcoat it so that the lawyer will be thinking, you know, this is the case. There's something that we call client confidentiality. So if you came to see us, you're coming to see us in confidence, and whatever discussions that you have with us remains confidential. And so you have to open up. It's just like you go to the GP. If you're suffering from headache and you go to say, well, it looks as if my tummy hurts, then you
They'll give you medication for tummy hurt anyway.
for tummy ache. So just be clear that it's your headache, not your tummy, so that you get the right medication.
Right.
If you come to say, well, it looks as if I went before, I mean, you're not going to tell me.
You're not helping your case.
You're not helping your case.
Now, somebody's asking, can I be deported if I applied for 20-year residence and the Home Office refused the application?
Well, if Home Office refuse your application, the first thing they're going to tell you is that because you don't have any thing in the UK, then be prepared to go. But then they also will tell you in that decision that, if you have another means that you can stay here, if your circumstances change, then you can come back to us. So yes, they may come and give you a decision which is telling you all of those things, but then it doesn't mean that.
So in that refusal, would they say you have a right to appeal?
Of course, yes, yes, yes. If it's an appealable decision, then yes, you would have the right to appeal. So, for instance, if you applied under the 20-year rule and you were refused because they say, well, your evidence did not add up to the 20 years, of course, you would get a right to appeal against that. And that appeal process could take a very long time because, bear in mind, once you lodge your appeal, it goes through a certain process. You may be looking at maybe about 6 months or so to get maybe a hearing. And once you go through the hearing, if you are not successful, you can still appeal against it to the upper tribunal. And that could go on and on and on and on till you get the right decision. And whilst you're doing that, your circumstances might have changed. You probably might have had a child. And, for that reason, you could put in even another application, or that could even bolster your chances of you being successful with your appeal.
Right. Another thing here, because of confidentiality, data protection, I wouldn't put this on the screen, but somebody has shown the GP medication record that spans the 20 years. Would that be enough to kind of screenshot and add to your application instead of, say, going to the GP to give you a letter to say that I registered at this GP this date and time?
Of course, that should be fine. So when you're giving your prescription script, you'd have a date on there and your name on there as well. I think some of them even normally comes with your address on there.
Yeah.
So yes, if you got all of that for that period of time, I think this would be a whole box full of prescription slips. But yes, why not? If you've got that, then by all means, yes, you can use that.
Right.
Yeah.
Yes.
For me, just to add this to it, for me, you probably save yourself time and energy by just going to the GP to request for the full data, which would have all of the times that you've been there on there, and it makes it a lot more easier. However, if you've got this and you feel that, because the GP will charge you to provide the report, and if you're not in the position to pay, then maybe, yes, you can fall on your evidence that you've got it, yes.
07399208468 or 020812311016. Text and WhatsApp 07950422780. You can leave your comment on the platform, either Facebook or YouTube. Will pick that one up, or you can decide to call us or send a text, a voice note, everything. Lawyer, this person says he needs assistance. He came in last week and has come back again. Please, I need UK visa from Ghana. I need assistance.
Well, I mean, there's no one way of coming into the UK legally. There's so many of them at the moment. The one which keeps coming up currently is the health and care visa route or the skilled worker route. And we know that even since February, they've included teachers as well. And so if you're a teacher and you've taught in Ghana or outside the UK for some time and you're qualified, you can come here and teach if you possess the right qualifications. We also know that with the health and care visa route, if you are somebody who possesses the right proficiency in English, you can apply to come if you get someone to provide you the certificate of sponsorship. So what you do is apply to care companies who are willing or who are ready to provide you with course, who are willing to employ you. Once they've employed you, they will give you course and you use that course in making your application. You need to have, if they are not certifying your maintenance, um, um, some level of money in your account. I think it's 1,275 for 28 days before you apply, and you need to be able to show that you meet the proficiency in English. If you have a degree, you can do the ECTIS, and the ECTIS will be able to show whether or not you meet that requirement. So that is not just that. If, say, for instance, you have, a partner here, maybe you're married and your partner is settled here, again, you can come under the Appendix FM route as a spouse. If you're a person who is an EA now and you have a child in Ghana, even though we're no longer part of EU, yes, still, your children, your parents, your grandchildren are all able to come and join you now. So these are some of the routes. There's so many others. I think, it will be the whole day going through all of them one after the other.
Yeah. This one says, my second question is, can someone who has pre-settled status bring her children who are 37 and 28 years to join her? What are the requirements?
Okay, somebody who has a pre-settled status, I think it would have been lovely if this person was on live radio so that we could ask questions.
Right.
However, this is what I think is happening there. If this person that is brought us this question is an EA national and they have a pre-settled status, then yes, they can bring their children. 37 and 28, it doesn't matter. What they need to show is that, first of all, there is relationship. So relationship proving that these two people, even though they are 37 and 28, they are your children. That's number one. The other thing is to prove dependency. So because they are over and above the age of 21, you have to show that these two depend on you financially. So you're the one that sends them money. Perhaps you've rented a place for them in Ghana where they live, or it's your own property. This is where they live. You pay for the electricity bill and water bill and all of the other things for their enjoyment. If you are able to show that, then yes, you can bring them into the country. The flip side is that if this person is just a family member of an EA national and has been granted pre-settled status, then they are not able to bring their children under that route, unfortunately.
Right. Another one here says,
So
okay.
just to add to that,
Yes.
when I say they are not able, it is not to say that not at all. So they are not able to in the sense that if they only have pre-settled status and perhaps they are no longer married to their EA national, then on their own, as somebody who possesses pre-settled status, is not going to be able to do that. However, if they're still married to this EA national, then they can rely on that relationship to bring children as the stepchildren of the EA national.
All right.
Yeah.
There was one question I wanted to pick. Okay, yeah. I want to migrate to Canada. Would the requirement be the same as the UK?
Well, we unfortunately, not privy to the requirements of obtaining a Canadian visa because we're unfortunately not Canadian lawyers, even though we would have loved to, understand their requirements. But we're not Canadian trained lawyers, so we would not be able to advise you on what the requirements are in migrating to Canada.
Would that be the same situation for any other European country?
When you say the same for other European countries, I'm not sure. You mean the requirements? Or?
Yeah, the requirements to migrate to another European country. Would that be the same as the UK?
Well, yes. So if you're migrating to the EU, say for instance, if you're going to Italy as a family member, because we're all in the same union, the laws that applied at the time to the UK would have been the same laws that would apply there. They would have their own domestic laws, which would also come into the play. But if you're migrating as a family member of an EU national, then pretty much it's the same law that would apply in your case. So you're traveling from Ghana with a family permit to go and join your Italian father or Italian mother. You go there, you'd obtain, I think, what they call sojourner, and then perhaps after that you get what they call the carta sojourner, and then through that the process you get your citizenship. So pretty much the same, yes.
If you just joined us, we live on BWTV, BW Radio, live on BWF Solicitors Facebook page and YouTube page. And we're discussing how to prove to the Home Office that you have not left the UK since your arrival 20 years ago. And yeah, the segment where we're picking up your comments, your questions, any issue that you would want to come to the lawyer with when it comes to immigration issues, nationality, family law, you want to acquire property here in the UK or Ghana, you can bring that one up. The number is 0208-123-1016 or 0739-208468, or you can put the comment on the platform and we will pick that one up. One here, my guest is lawyer Patrick of BWF Solicitors. BWF Solicitors 0208-493-7340. Can a surrogate mother pull out of the contract before the baby is born?
Well, they can do, if for whatever reason they want to pull out of that contract, then it be within their own right. I think from the experience that we've had on this platform, we've seen that things happen. People, for whatever reason, can frustrate a contractual agreement. And if, they say this is what I'm going to do, it's difficult to tie them in there. There may be something to compensate for what they do, i.e. the time that they've wasted, the money that you've wasted on them. However, I think it'd be very difficult to tie them into a contract if they indeed want out.
Then, so the mother that's carrying the baby,
Yeah.
she must have formed affinity with the baby in the womb.
Yeah.
Before the baby is born and she is dragging her feet, develop cold feet, and will say, well, I don't want to continue anymore. At that point, the person who has engaged the surrogate mother, what does the person do?
Well, if somebody is pregnant with your baby, then indeed, until that baby is born, we wouldn't know the paternity or the, if you like, well, we know a child born by a woman would be, that person's child. But then the paternity is the one that we would question. And until that baby is born and we've done all of the checks, we're not able to tell with our eyes that indeed this child, Kwesi, is the son of Mr. Mensah. We would have to go through checks, i.e. maybe DNA, to prove that indeed this person is this person's child. So if it comes to that, then you may want to pursue this through the courts to say that indeed this child is your child, and go through the right channels to get the child back. Yeah.
The person sent in a question about the 37-year-old and 28-year-old children has sent in a follow-up question and says, my question is, can she bring grandchildren to join her since she has pre-settled status?
Yes, she can. So we've mentioned a short while ago that if you're an EU national and you are here in the UK, you can bring your children and you can bring your grandchildren, you can bring your parents all into the UK, even though UK is not or no longer part of the EU. You are still able to do that with your children. If they are below the age of 21, then all that you're showing is relationship. If they are above that, then you need to prove two things: relationship and dependency. So those are the things that you need to keep in mind. For your grandchildren, again, the consideration would be the same. If they are below 21, yes, they're your grandchildren, they can come and join you, and you need to prove relationship. If they are beyond that, then you have to prove relationship and dependency. So yes, with your pre-settled status, you can still uh, bring them to join you. However, based on your own circumstance, you need to figure out which one of these relates to your case. Yeah.
Right. We're still soldiering on. You can bring in your questions. One here says, what are the consequences for using someone else's document to work?
Well, so first of all, we're not encouraging you to go and use somebody else's documents to work because that is illegal. But where you've done that in the past and you have the evidence and you require the evidence to support your claim that you've lived here for 20 years, then we know from the experience of Mahmoud that the court would accept them as using those documents to prove the continuity of your residence. Just for that and not for anything else. Anything else will be outside of that remit. What we're looking to find is if we put together those documents and add it to, let's say, what you already have, would you be able to accumulate the 20 years 20 years long residence to prove your case? If the answer is yes, then yes, of course, you'd be allowed to use that at that time to support the claim that you've been here for 20 years. It is not to advise you to go and use somebody's documents to work, because that is illegal and you're not allowed to do that. You'll be, if you like, impersonating somebody, and it's not going to be very nice.
Kwame Chikwuating says, can a charity worker or religious worker switch to the health worker route or any other route?
No. So once you're here on a charity worker basis, that's what you're on. You're working for a charity. So if you take, for instance, the skilled worker, if you come to the UK on the skilled worker route, you're restricted to working with this person that is sponsored. And you can do full time with them. You can do a bit of part time in the same industry with somebody else, but not more than what you're doing. So yes, even though you are working in that industry, that's what you're restricted to be working in. It's the same thing with the charity one. You come as a person who is working for a charity company, the organization that brings you, you're working for them. If you're going to go and move on to do another charity, then yes, that's fine. You're doing another charity. And if you're going to go work full time for that other charity, then you're saying that this other charity that sponsors you is withdrawing their sponsorship, and now you're taking up a new sponsorship with another charity company.
Our friend Collins Body sends in this one and says, my friend's administrative review has taken more than 2 years. What should he do?
Unfortunately, at the moment, administrative review, it's dragging on. And, yes, he's right. Some of them have taken even longer than 2 years. And the only reason, that is the case is the fact that they have backlog that they are dealing with. So all of the applications that we've made, the 3 million people that applied under the U.S. settlement scheme and more, those that were refused, not just that, but under the actual domestic immigration rules, all of these people, those that have the right to take administrative review and follow that through, are waiting. So there's a serious backlog. And so normally you get them send you an email, sometime to say, yes, it's taking longer than the time that we said we were going to use to process it. But this is only because that we have a backlog, and there's not much. Now, if you feel that it's taking too long, and you think you have what it takes to submit a new application, then you may be able to do that, to submit a fresh application. Say, for instance, you are a family member of an EE national. You submitted your application for limited leave to remain as a wife, and maybe you were asked to attend a marriage interview, and at that marriage interview, something happened, or you couldn't even attend, or something happened, and your application was refused, and you decided to put in administrative review to review the decision because you have justifiable reasons why maybe you did not attend the marriage interview, and so the refusal is not justified. So you've done that. But if this is dragged on for 2 years, perhaps even putting a fresh application from the onset would have,
be better.
gotten you the right decision, from there on, than waiting for 2 years to go through the administrative review process.
Nana, I thank you for waiving our test. God bless you. Nana Kwame Tinkrai, thanks. But their dependents can their dependents switch to any route? Was it a follow-up to a previous question? Can a charity worker, religious worker switch to health worker or any other route? And then you're asking, can their dependent switch to any route? So the charity workers coming here, the dependent is qualified under that license maybe. Can they switch to any, can they do work in any industry?
Well, so just as the skilled worker route, it's the main applicant who has been given the course, who is tied down to the organization. And so you have to be working for them. If you're a dependent, you can fly like a bird.
Make sure you jump on a tree. Okay.
So, yes, so you can go flying and do whatever you want to do. And so long as you're living here legally, then you're good to go. So normally, the dependents have the freedom to go and work for anybody and with anybody at all. And if they decided to switch, then they switch into something else to stay. Yeah.
Okay. You can send in your text, your comments, and put them on the platform, or send them to our text message phone, or you can call us if you so wish. Your language, any one you choose to. So let's go to the platform again. Kwame Chim, I think we've had that. If there are any of the ones that we picked from yesterday's program, we can bring that in. I applied for a British passport for my son in 2019. I've only just realized that they put the wrong year of birth in my son's passport. How do I go about rectifying it?
Okay. So if they got the date of birth wrong, yes, you can send it back to them, and they will do the and bring it back to you. Yes, it's human. Somebody is inputting data. The possibility of getting it wrong, yes, is there. It doesn't mean you have to accept that as it is. No, you can take it back and point out what the error is, and they will correct that and send it back. This should not be a problem at all.
Okay. Your text 0795042780. Let's pick another one. Amir Jiwa, my question is, please, are there delays in the naturalization applications, because I submitted my application form last year, September, but still I have not heard anything from them. I dare say that September to February, it hasn't been too long. People have gone 11 months.
Well, so the naturalization application consideration process is a bit different. So it's not the same as you applying under the family route and the private life route, where we know at the moment you're having to wait 11 months onward to get a decision if you make a standard application. With the nationality, the standard consideration time is 6 months. Sometimes they are able to consider it a lot more quicker and give you a decision. I think September to now, we're looking about 5 months onwards. So you're not too far off the 6 months mark. And so you never know. Hopefully, by the end of the month, you should expect to get something through the post. And
are you putting something of that?
Well, I'm saying that yes, that's likely to happen, because yes, we should get through that. Yeah.
Okay. My best friend's wife is a French teacher in Ghana. She wants to come to the UK through the teacher's route. Can you explain the procedure and requirements and the fees?
Well, so if you're applying to come as a teacher again, we want to know if you're a qualified teacher from the country where you're coming from. Uh, Maybe you've had experience, you've taught there for a while since your qualification, and you're able to demonstrate that. Now they've opened the route for you to do what register with QTS, so qualifying teacher status. That is what you need to basically show that yes, you're a qualified teacher and you can get into the field here. So you do once you've registered online to obtain the QTS, then you are recognized as somebody who has got the experience and the qualification to be able to come here and teach. Then the other thing you're looking to do is to find a school which has got the sponsorship license and ready to sponsor you. It's just like you're looking for work. So go online, do your search, schools that have sponsorship license and are recruiting from outside the UK. Apply to them. Once you get your sponsorship, then you're making your application. For the maintenance is about the same as the skilled worker one. The fees is run about the same as well. And those are the things you're looking to do to make the application to come through. Yeah.
Okay. This one says both my wife and I are on student visa. My wife is schooling, but I didn't. Can I apply as an independent? And what are the requirements?
So,
Both
wife,
are students.
okay,
Wife is still in school, but
right,
he didn't.
okay.
Can he now apply as the dependent of the wife now?
Well, it can do, yes. So you were a student yourself. Now you're no longer studying, but your wife is a student and you want to switch to a dependent visa. Yes, you can do that. And because you have leave post, which is not been cancelled or revoked, it'd be a lot more easier for you to switch in country.
Well, I have a little surprise on my phone, and I know the person really wanted to trick me, but I found out. Now, my Etsy, good evening.
Good evening, Eric. Good evening.
Why are you through the back door?
Oh, it's just because I've got some visitors with me, and
I want to see their
I didn't
faces.
want to come on the video. Oh my day.
Anyway,
Okay,
good
let's
evening.
give
How are
some
you?
time. I'm good, thank you. So greetings, Mr. Patrick. Love, Sir Patrick.
Oh, hi. Yes, good evening, Anya.
Okay, I have a quick question.
Uh,
Very technical.
yes, let's see.
Okay, I think somebody just wants to do the system, but let's see how it goes. First of all, I have this person, who came here with a co-sponsored visa. And actually, the lady came with the husband, and the lady is a main applicant. Okay, sorry, the husband rather is main applicant. So the wife is dependent on him. Now, the husband started doing this care work and realized, that's not actually his skill, and the work is too tedious for him to do. So he really wants to quit, but thinks he could get a different sponsor, but because his visa is on the care worker route, it's a bit difficult for him to do that. So the wife rather wants to do the care work, and she's asking if she finds a sponsor here. And now the husband is coming to be a dependent on her. How would the husband switch that his sponsorship or leave the sponsor and then come and be under his wife's vice versa? Sorry.
Okay, so a very interesting scenario. One has depended on the other. The main applicant said, well, that's not my area, so I would want to quit. The wife finds that, no, this is my area. So technically, I want to swap. Can they swap positions? Really?
Well, of course they can.
Mm.
So, just so that listeners are not confused, when you say can they swap, I didn't suppose you meant that the woman would take
Go, take
the
the admin
man's
license.
position and take the course, and then
No, no,
that's
no.
not what you
No,
meant.
that's not.
Yes. So swapping is, basically the question that Manya asked us, whether the lady can apply through another sponsor who would be willing to provide sponsorship. And then once our dear sister is obtained the sponsorship, the man
Can
can
quit
quit his job
and
and
become
then
a dependent.
apply as a dependent of our dear sister.
Yeah.
That's absolutely fine. So, yes, if you're no longer happy to work with this company, then they will withdraw their sponsorship. Once they've withdrawn, you are able to, or you can apply on the basis of you being a dependent of your wife. You're married, supposedly, you came together on your sponsorship. Now you want to be her dependent. Yes, you are able to do that. Yes.
So in that case, with the man, the lady came under the same sponsorship and is a
Yes.
dependent there.
Yeah.
If she finds another sponsor and she goes under that course, would she have to notify the initial sponsor to say that I was a dependent, now I'm going under another contract, so can you relieve me off my husband's bid?
No, she doesn't.
She
So
doesn't have to do anything.
she hasn't got any contract with the sponsor.
Okay.
It is the husband, the main
Right.
applicant, who has this the contract with the sponsor.
Mm-hmm.
And so, like I said, short while ago, the woman can go flying and do whatever she chooses to do.
Okay.
And so, if she gets a sponsor, then yes, she's going to be okay to move on. And then once she's gotten the sponsorship certificate, be able to get the husband to join on that course. Yes.
Well. Time and tide is a way to no man can never be exceptions to this general rule. We have been, as a main topic, discussing how we can demonstrate to the Home Office that we have not left the country, the UK, so to speak, since we arrived 20 years ago, and lawyers taking us through the technicalities and showing us what to do. Your questions and your concerns have come through. I think most of them have been on this care work route and applying for yourself and your partners, spouses, children, and the rest of it. This is the time for us to go back and pick our quiz. In that segment, I'll be coming back. But before I go, let me just go to the nugget and read that again quickly. Then I will take a break, and when we come back, I'll ask my question. Now, surrogacy arrangements mean a woman carries and bears a child on behalf of someone else. The woman who carries and bears a child is a surrogate mother. However, she can do this without being genetically related to the child. The sperm and egg necessary to create the embryo can come from donors, and the embryo can be implanted into her. In such circumstances, any resulting child may have no genetic connection with a surrogate mother or her husband if she has one. Under UK law, when a child is born to a surrogate mother, the parental responsibility for that child rests with the surrogate mother. In this case, the father of the child is the husband of the surrogate mother, or if she is not married, the biological father. This is quoted from Section 59(9)(c) of the British Nationality Act, and I read this in conjunction, with the British Nationality Proof of Paternity Regulations of 2006. We'll be right back.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community,
is a member of the Family Law Panel
and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Okay, we're right back, and we're moving into our quiz segment. And I want to test your knowledge. Remember, Laura said we bring you the nuggets to enrich your knowledge and also make you confident to be talking about the law. So let me go to the question here. Amma Mansa, British citizen, is married to Kofi Brew, also a British citizen. In 2022, they commissioned Ama's sister, Equiarus, as a surrogate to carry their child. Amma had no genetic connection to the child, but Kofi provided the sperm to fertilize a donor egg for the baby. The baby was born in Ghana in January 2023. That's quite recent. Amma Mansa, a British citizen, married to Kofi Brew, a British citizen as well. In 2022, commissioned Amma Equiarus as a surrogate to carry their child. Amma had no genetic connection to the child, but Kofi provided the sperm to fertilize a donor egg for the baby. The baby was born in Ghana in January 2023. What will the nationality of the baby be? 1. As the male of the commissioning couple has a genetic connection with the child and the surrogate mother is unmarried, the child is British. I repeat that. As the male of the commissioning couple has a genetic connection with the child and the surrogate mother is unmarried, the child is British. Number 2, as the child was born in Ghana to Equiarus and she is the mother, the child is not British. 3, as the child was born in Ghana and Amma has no genetic connection to it, the child is Ghanaian. So consider these 3 answers. Look at the questioning and the scenario again. Amma Mansa, British citizen, is married to Kofi Brew, also a British citizen. In 2022, they commissioned Amma's sister Equiarus as a surrogate to carry their child. Amma had no connection genetically to the child, but Kofi provided the sperm to fertilize a donor egg for the baby. The baby was born in Ghana, January 2023. Now, let me make life a little easier for you. Let me go back to the nugget and go through the quote again. Surrogacy arrangements mean a woman carries and bears a child on behalf of someone else. The woman who carries and bears a child is a surrogate mother. However, she can do this without being genetically related to the child. Does it ring a bell? Okay. The sperm and egg necessary to create the embryo can come from donors, and the embryo can be implanted into her. In such circumstances, any resulting child may have no genetic connection with a surrogate mother or her husband if she has one. Under UK law, when a child is born to a surrogate mother, the parental responsibility for that child rests with the surrogate mother. In this case, the father of the child is the husband of the surrogate mother, or if she's not married, the biological father. Quoted from Section 59(9)(c) of the British Nationality Act. I read this in conjunction, as I keep saying, with the British Nationality Regulations of 2006. Now, back to the question. Now, it says that I'm a Mansa British citizen. I virtually am answering the question. I don't want you to be confused. Last week you tried to sway lawyer into a very kind side, and for him thinking probably confused you. So today I'm very making it very clear. I'm a Mansa British citizen, married to Kofi Brew. Okay, a British citizen, both of them. In 2022, they commissioned Ama's sister, who is not a British citizen, Aquarius, as a surrogate to carry the child. Ama had no, Ama Mansa, had no genetic connection to the child, but Kofi, her husband, provided the sperm to fertilize a donor egg for the baby. The baby was born in Ghana 2023. So what would the nationality of the baby be now? Flow with your answers. Let's go. Um, okay, first one here. Kojutupo says, number one, as the male of the commissioning couple has a genetic connection with the child and the surrogate mother is unmarried, the child is British. Interesting. Okay, let's see. What else do you have? You can text that to me, 0795042270. Thank you very much, Mami and Kukua. You have joined us. Oti, thank you for joining. King Zach, Ekosia Part, Newman, Afenu, Beatrice, all of you have been contributing. We have Dani and all the other ones. Wumpe Adam, yes, I've just seen you. Congratulations. Good afternoon. You didn't answer my question. Oh, Mami, I'll take you. I'll keep your question and bring it up next time because I think we're running out of time. Penny says, "I love BWF Solicitors." Well, Mami, I'll pick your question later on. But I think I've got only one answer. Okay, Ademunukum says number two. As a child was born, uh, can you push this one? Yeah. As a child was born in Ghana to a Rose, and she is the mother. The child is not British. Which is the answer? I've got two. I've got one. I've got two. Somebody to come with me and to do one. Like, what will be your answer?
Okay, so the answer is one. I think from the question, we can deduce the answer from there. And from the statement that you read preceding the question also gives away the answer so easily. And I think failing that, the discussions that we've had so far basically gives out the answer as well. So the key things you'd be looking for, say for instance, if you were sat in a law exams room, would be the fact that the question mentions genetics and the fact that it mentions British citizen. So we're looking at the genetics of the man, and then we're looking at the fact that the surrogate mother is not married. And so therefore, if the child has got the man's genetics and the surrogate mother is not married, then we know from section 59A, which defines the paternity of a child for nationality purposes, is the fact that is a person who was married to the mother at the time of the child's birth. And then if you drop down, it comes to section 59C, which incorporates the Embryology Act 2006 and the rest of them. So that is where this our friend falls. So even though he's not married to the woman that brought forth the child, however, he's still covered under 59 to C because of the embryology insemination that was done, which basically was from.
So if the surrogate mother had a husband at the time, then the child's nationality would have gone to what nationality the supposed husband had.
It's as simple as that.
Okay.
So that would have been, the nationality law kicking in from there. So if there was a husband there, then it would be the case that this husband would be the father of this child, even though biologically, genetically, not connected to this child. So that would have been the unfortunate situation. But we've said it so many times that this very particular legislation cuts both ways. So I think in the last couple of weeks we discussed this, where we saw that if you were born in Ghana to parents who were married at the time, even though you perhaps you were not the biological child of this father who was married to your mother for whatever reason, the fact that you were born into marriage, then you are able to apply for a British passport on the basis that at the time of your birth, your
Your
mother was married to a
father
person
was
who is a
British.
British citizen, and therefore you would have a claim to British citizenship. And it doesn't matter how old you are now, you can still apply.
Ooh.
Yes, because it would be the same way if you were perceived to be another person's child. It wouldn't matter how old you be now, they will still be able to revoke your passport if they found that, and then say go and apply under the new route that they have provided. So it's the same way. If you think at the time of your birth your mother was married to somebody who is a British citizen, and you can demonstrate that, maybe you would have a claim to a British passport, and you may find yourself traveling on the next flight to the UK on a British passport.
Passport. Well, that said, we have come to the end of our discussion and a very wonderful experience with Lawyer Patrick from BWF Solicitors. Thank you very much, BWF Solicitors, for your kind sponsorship and your guidance. And as I don't want to break tradition, I'll give Lawyer the next minute to round up and also say thank yous to you. Lawyer.
Okay, so first of all, thank you very much, Senior, for having me back again. I think
It's good to have you.
it's been two on a trot, and so
It's good to have you back.
so I'm very grateful. Thank you to the rest of the team, Professor Dai, for basically spending the weekend with us once again, and to all of the crew who are pulling the strings from wherever they are. We're very grateful for their support. We thank the community at large as well. They've been absolutely wonderful, and they've held us all the way through from when this program started in a little corner somewhere to date. They've been very, very, very supportive. They've
That's
helped
right.
the brand to grow, and we are very, very thankful. We ask for their continuous support. We're not there yet. We're still trying so many things, and we ask that they continue to support us. Again, what we would say is, bear in mind, if you've lived here for 20 years, you can make an application on the private life route. Don't hesitate to do it if you know you've been here, in fact, for 20 years. Whether you have the evidence or you don't have it, it is not for you to say that the application is going to be refused. That decision making is not in your hands. So yes, make your application and then leave the rest for the caseworker to deal with. If you're unfortunate and you get a refusal, yes, you'll still be able to appeal against that decision and fight your way through it. So that is what you need to know. If you're a child who's been born here and you have lived here for the first 7 years of your life, we know there's been changes in the law since July last year. You would be able to apply for indefinite leave to remain. We know before you'd only be able to apply for limited leave to remain. Now that is all changed. You can apply for indefinite leave to remain. If you came from abroad and you've been on a limited leave to remain for 2 consecutive times, making it 5 years, again, you can apply for indefinite leave as well, as opposed to being on a 10-year route. So there's been a lot of changes, very, very advantageous, and would like our community to explore. Speak to experts if you don't know what you're doing, because some of these things you may find very easy once we come to discuss and dissect them. But there are sometimes some crooks and cronies, technicalities that you may not know. Speak to an expert to guide you through the process. It may cost you a few bits and bobs, but hey, to get a successful decision, it would be worth spending that money. Don't go and speak to the car boot salespeople. In fact, it wouldn't help you. So thank you very much for joining us. It's an absolute pleasure joining you again today. God bless you until we meet again. Bye-bye.
Well, and until I also say my goodbyes to you, please wait and let me say a proper thank you to you. It's been a pleasure. It's been a wonderful one and an utmost nice duty to have hosted this program. I want to say thank you to my studio director and manager, Professor Ade, Sheila Ankara, and Padmo Dutu for doing the technical bits in the background, and to BWF Solicitors, our wonderful family, Uncle Ben, Auntie Eunice, Cynthia, Lawyer Richard, Lawyer Patrick, Lawyer Charles, and everybody at BWF Solicitors. I doff my hat to all of you for your kind support and, of course, your continued encouragement that we bring you the community and the law. And to you out there, without you, I wouldn't have had a successful program. So I would want to say thank you and ask again that you join me same time next week on the same platform on BWTV, BW Radio, and all the social media platforms for BWF Solicitors. My name is Ulrich Kofirpon. Have a good evening.
Yeah. Jesus, you're my everything, yeah. My everything is you, Lord. Yeah. Oh, oh, oh. Oh, oh, oh. Everybody say, ah. Say, how can I